The second edition of the Public Interest Symposium series, instituted by the Island Club, Nigeria's premier social club, which is a strategic social responsibility advocacy intervention program to seek solution to urgent national programs, has taken place in Lagos. This is a follow-up to the inaugural edition, which was held in Lagos in September 2015, where experts from the various arms of the security agencies cross-fertilized ideas to profess solutions on how Nigeria can quickly end the war on terror, which has brought the northeast part of Nigeria to its knees since 2009. The second edition of the Island Club's Public Interest Symposium series focused on how to fight and win the war against corruption, an endemic cankerworm which is eaten deep into the fabric of virtually all facets of the Nigerian society. There couldn't have been a more appropriate person to deliver the lecture than the renowned human rights crusader, a dogged anti-corruption campaigner, an erudite professor of law, senior advocate of Nigeria (SAN), and chairman of the Presidential Committee on Anti-Corruption, Professor Itse Sagay (SAN). The chairman of the event was Honorable Justice George Adeshola Oguntade, CON, CFR, a retired Supreme Court judge, noted for his exceptional courage and knowledge of jurisprudence. The special guest of honor of the event was Nigeria's erudite and most distinguished External Affairs Minister Emeritus, Professor Bolaji Akinyemi, CFR. The esteemed patron of Island Club, Governor Akinwumi Ambode of Lagos State, was represented by the Executive Chairman of the Lagos State Universal Basic Education Board, SUBEB, Dr. Shogbenyi Ganiu Oluremi. The Acting Inspector General of Police, Zone 2, was also represented. The Vice Chairman of Island Club, Ashiwaju Barrister Adeyinka Shogunle, past Chairman and Trustee of Island Club, Alhaji Chief Musiliu Olaya Anibaba, led other past chairmen, trustees, and indeed members of the Island Club who gave a very robust support to the Chairman of Island Club, Mr. Oladipo Okpesheyi, SAN, the main convener of the forum. Setting the tone for the commencement of the symposium was the fearless and courageous judge, Honorable Justice George Adeshola Oguntade, CON, CFR, whose tenure as a Supreme Court judge witnessed the delivery of many landmark judgments, which have impacted significantly on Nigeria's legal system, particularly in the areas of constitutional and administrative law. Fresh from presenting a paper at an international symposium on economic crimes in Cambridge, England, on fighting corruption and money laundering in banking, his opening remarks were vintage Justice Oguntade, short, measured, and very instructive.
On a particular occasion, the retired Chief Judge of Bende State, Justice Mason Amato Sherubehu, I was working with him, had cause to sentence a white man to punishment, even at a time when Nigeria was under the colonial rule. The lesson being disseminated by such occurrences at the time was that crime, after every crime, punishment must follow. When a Nigerian could, while under colonial rule, sentence a white man, it shows that we had men of courage in the land for many years. The main lesson I draw from it is that in Nigeria of today, the only way we can stem corruption is after every commission of crime, as soon as the culprit is brought before court, he must be promptly punished. That's the only way we can communicate to the public and to ourselves that corruption will not be tolerated in the land.
In his remarks, the chairman of Island Club, Mr. Dipo Okpesheyi, SAN, began by tracing the genesis of the formation of Island Club 73 years ago by the motivation to foster interracial harmony and project the dignity of man, irrespective of race, color, language, political or religious leanings. Island Club also came into existence to assist government in promoting people-oriented policies and programs. It is in the light of this that the Public Interest Lecture as a social responsibility to seek solutions to national problems have been instituted.
The Island Club, a club founded on Friday, 29th of October 1943, by 50 distinguished gentlemen whose origin cut across the globe. The common aspiration of these great gentlemen was to foster interracial harmony and to protect the dignity of man anywhere in the world, irrespective of race, color, skin pigmentation, language, creed, political and/or religious leanings, and also to assist government in promoting people-oriented policies and/or programs.
In the goodwill message of Governor Akinwumi Ambode of Lagos State, delivered by his representative, he said that corruption has not only led to the impoverishment and loss of lives, but also has a lot of negative consequences on every sphere of societal development, social, economic, or political. Therefore, the fight against corruption must be for value reorientation to transform the society and humanity. Governor Ambode urged the collective effort of every Nigerian and the civil society organization and the strengthening of institutions to sustain the capacity to identify acts of corruption and ensure that people who indulge in or benefit from such acts are made to face the wrath of the law.
Corruption is undoubtedly one of the greatest challenges of our time. A challenge that has not only led to impoverishment and loss of lives, but also threatening the stability of our society. In fact, it has a lot of negative consequences on every sphere of social development, whether social, economic, or political. The fight against corruption should be a fight for value reorientation to transform the society and for humanity. It is against this background that the government of President Muhammadu Buhari has displayed the commitment to fight corruption by setting the tone at the top. It should, however, not be a one-man show, but a collective effort that requires the participation of all Nigerians, including civil society organizations.
Before he mounted the rostrum to deliver the lecture, Professor Adele Jinodu, chairman of the subcommittee of experts which coordinated the symposium, read the citation of the erudite legal luminary, one of Nigeria's sharpest legal minds, who has continued to demonstrate unrelenting determination to the creation of a new Nigeria. Professor Itse Sagay, SAN, is an accomplished legal scholar who has made a distinct mark in constitutional law and international law. Professor Sagay's acceptance to serve as the chairman of Nigeria's Presidential Advisory Committee Against Corruption is a further testimony of his unflinching and unwavering faith in the future of Nigeria. Professor Itse Sagay, SAN, the guest speaker at Island Club's second Public Interest Symposium with the theme Confronting the Scourge of Corruption in Nigeria, began by signposting the negative impacts of corruption. Professor Itse Sagay said corruption is an obstacle to economic growth, development, eradication of poverty, improved life expectancy, good health, good education, and improved livelihood of all Nigerians. Professor Itse Sagay stated categorically that corruption is the cause of Nigeria's low Human Development Index.
There is a general consensus that corruption is an obstacle to economic growth, development, eradication of poverty, improved life expectancy, good health, good education, and improved livelihood of all Nigerians. Indeed, it can be stated categorically that corruption is the cause of Nigeria's low Human Development Index. In addition to the above, corruption is responsible for poor policy choices, white elephant projects, mass unemployment, and the general misery and wretchedness of the masses of this country.
Professor Itse Sagay, SAN, stated that the Human Development Index is a comparative measurement of the life expectancy, literacy, education, and standard of living. He said that this year, Nigeria was ranked 152nd out of 188 countries with the lowest Human Development Index, HDI, with countries like Togo, Benin, Central African Republic, Burkina Faso, Chad, Haiti, South Sudan, Zimbabwe, Sierra Leone, and Mali, even though Nigeria has enormous natural and human resources compared to these countries.
These depredations on our national patrimony is reflected in our dismal position in the Human Development Index, which is a comparative measurement of life expectancy, literacy, education, standard of living, and so on in this country. It is a standard means of measuring the general well-being of the population of the country. This year, Nigeria was ranked 152 out of 188 countries worldwide. But what was very galling and depressing was that we were classified amongst countries with the lowest Human Development Index.
Professor Sagay said that corruption has taken a heavy toll on our development and standard of living. Professor Itse Sagay said that the emergence of President Muhammadu Buhari has marked a turning point in the fight against corruption. He affirmed that anti-corruption agencies like the EFCC, the Code of Conduct Bureau, ICPC, and the Presidential Advisory Committee Against Corruption, which he chairs, working in tandem with other security agencies like the Nigerian Police Force, Nigeria Drug Law Enforcement Agency, and the Bureau of Public Procurement, have been galvanized to take more active action to curb corruption. The agencies have begun to back and bite. Professor Itse Sagay, SAN, said that the Presidential Advisory Committee Against Corruption, of which he is chairman, was established in August 2015 with the mandate to coordinate the fight against corruption and development of comprehensive intervention in Nigeria's administration of criminal justice.
The eradication of corruption was a major plank in President Buhari's campaign, and as soon as he assumed office, his famous body language became the indicator for public conduct in the management of our resources. Apart from Buhari's unimpeachable integrity and non-intolerance of corruption, which he has demonstrated since 1983 when he was a military head of state, the various anti-corruption agencies, which had earlier on gone to sleep, have suddenly roared into life, galvanized by the leadership and unshakable determination of the president. We are presently witnessing the dynamism of the EFCC under new leadership and that of the Code of Conduct Bureau in recent months. The ICPC is also manifesting some resurgence in its activities by its seizure of properties acquired by public servants who could not explain how they came about them.
Professor Itse Sagay, SAN, said that the Presidential Advisory Committee Against Corruption, PACAL, is out to eliminate delays caused by preliminary objections and interlocutory applications, promoting the provisions of the law guaranteeing daily proceedings without adjournment in corruption cases, as well as promoting integrity in the trial process. The PACAL is also out to put an end to all orders of perpetual injunction against the investigation, arrest, and prosecution of anyone tried for corruption, saying that such person must defend themselves in court and such cases must go through the full trial process. Also, under the purview of the committee are the lifting of all existing injunctions, protecting anyone from investigation, interrogation, arrest, and prosecution for corruption.
The President established the Presidential Advisory Committee Against Corruption, PACAC. These are the specific bodies engaged in the anti-corruption struggle. There are, however, others, like the Nigeria Police Force, Nigerian Drug Law Enforcement Agency, and the Bureau of Public Procurement, which are also involved in the war, albeit not so prominently.
To facilitate the administration of justice, the committee is working towards a 4-point objective: efficient investigation, effective prosecution, speedy adjudication, and effective sanctions. The National Anti-Corruption Plan, still in the works, will improve interagency cooperation in fighting corruption, promotion of ethical reorientation at each level of the society on nation building, which will guide citizens from cradle to grave. Professor Itse Sagay, SAN, also spoke on other areas of law. For instance, he stated that where a public officer is convicted for breach of the code of conduct, such an officer will vacate any political office and will be disqualified from holding any public office for a period not exceeding 10 years. In addition, any property acquired in abuse of office will be forfeited to the state.
The FCC law, it covers every aspect of financial and economic activity. Every aspect. Money laundering, embezzlement, bribery, looting in any form, illegal arms deals, smuggling, human trafficking, child labor, illegal oil bunkering, illegal mining, tax evasion, foreign exchange malpractices, counterfeiting, theft of intellectual property, dumping of toxic waste, and so on. Very, very wide jurisdiction. And it also has powers for identifying, tracing, freezing, and confiscating or seizing proceeds derived from criminal activities. But the important point is that this is based on the condition that the matter must have been taken to court. You can't just go to anybody's house or office and start seizing things. It must be in court for it to exercise that power.
As regards the EFCC, Professor Itse Sagay said that the agency is empowered by law to cause investigations to be conducted into the properties of any person if it appears to the Commission that the person's lifestyle and extent of properties are not justified by his legitimate source of income, which means anybody living beyond his means. This investigation will unravel whether such a person or corporate body has committed an offense under the EFCC Act or under any other law relating to a financial crime. This will lead to investigation being conducted into the suspect's assets. Once conviction is obtained, the forfeiture is made permanent, where the assets of a person arrested under the Act have been seized.
Apart from the sanction of 21 years imprisonment for corruption and enrichment, and in fact, there has a drastic provision of life imprisonment for failure to declare full assets. It provides for the complete forfeiture to the state of all assets connected with commission of the offense. I find this law very attractive as a fallback law when you have a difficult case. It covers engagement in corrupt practices regarding the person who was arrested, but also covers corrupt practices in terms of enriching not only oneself but any other person. So if your act results in enriching a second person, then you are equally liable in addition to that person.
Or even if there has been no arrest, but a person's property has been seized because he or she is living above the lawful means, the Commission will first make an ex parte application to the court for an interim order of forfeiture of the property concerned to the federal government, and the court, if satisfied that there is a prima facie evidence that the property concerned is liable to forfeiture, shall make an interlocutory order forfeiting the property to the federal government. When the person is finally convicted, the Commission shall now apply for an order of confiscation and forfeiture if the convicted person's assets and properties acquired or obtained as a result of the crime following the earlier intervention order.
In its efforts to prosecute corruption cases, particularly by the use of illegal and unethical means of stalling and frustrating prosecution, there is one legitimate and potent weapon the government can resort to in this world. This is the Recovery of Public Property Special Provisions Act, Cap R4 2004. This act was formally Decree number 3 of 1984, Recovery of Public Property Special Provisions Decree number 3 of 1984, enacted during the first coming of President Buhari as head of state in 1984. It is still valid law in this country. For some, I would say, lucky reason, it was not deleted.
The ICPC Act goes further than the EFCC Act, as it provides that the courts can make an order for the forfeiture of any property which is proven to be the subject matter of the offense or have been used against the accused person, provided the court is satisfied that the accused is not the true and lawful owner of the property, and that no person is entitled to the property in good faith. Major challenges confronting the anti-corruption war, which are being examined, were also touched on. These include poor standard of investigation and prosecution. Examples are cases in which the investigators and even prosecutors have been suspected of being compromised to lose a case. However, according to Professor Itse Sagay, the real challenges comes from very senior defense lawyers who use their knowledge and experience to frustrate the prosecution of their clients by unethical methods. The list of underhand methods engaged by these senior counsel is long. This include bail application on medical grounds and frustration of the case after bail, frequent change of counsels, filing of preliminary objectives, frequent adjournment for flimsy reasons, compromising witnesses, incessant interlocutory appeals, political influence peddling to delay in quashing of a case, urgent striking out for want of prosecution, lack of evidence, or both urgent public and media support that the accused is a victim of witch hunt, a compromise of the court prosecution, or both.
The real major challenge comes from very senior defense lawyers who use all their knowledge and experience to frustrate the prosecution of their clients by unethical methods. The list of underhand methods engaged in by this senior counsel is long. If I may mention a few, they will apply for bail on medical grounds, and once the bail is granted, they frustrate the case. Then, when the case is making too much progress, they have a strategy. Change of counsel. Counsel handling it will suddenly withdraw. A new counsel will come and seek time to familiarize himself with the case. There's, of course, filing of preliminary objections, endless ones, frivolous and useless, frequent application for adjournment for flimsy reasons, my mother is sick, that sort of thing. Compromising witnesses, incessant interlocutory appeals, political influence peddling to delay or quash a case or get it struck out for want of prosecution or lack of evidence or both, or get the public and the media support that the accused is a victim of a witch hunt. Then there's, of course, something we're all familiar with, political rehabilitation of accused by high-profile political appointment, electoral victory into public office.
The Administration of Criminal Justice Act, enacted in 2015, tackles the problem of frustrating prosecution of high-profile corruption cases, stay of proceedings even when the case of an appeal has been prohibited. All cases must be heard from day to day. Where an adjournment is inevitable, there must not be more than 5 per case, and no adjournment should exceed 14 days. Any person who has compromised the process, be he a judge, a prosecutor, or an investigator, will be prosecuted and sent to prison like anyone else if found guilty. The judiciary is the very heart of the anti-corruption struggle. Without an upright judiciary, the whole anti-corruption war is dead on arrival. The ultimate objective is the establishment of a special anti-corruption court.
Under the new law, if you bring a preliminary objection, fine, judge will take it. But he will tell you, argue it, then I will keep it aside, I won't make any pronouncement. Now, let's have the corruption case. Also complete it. When you finish, I will give judgment on the two at the same time. That's the new provision. So there's no question of moving to the Supreme Court on one issue whilst leaving the other behind. The judge will give his ruling on the issue of jurisdiction and give his judgment on the issue of corruption. If you feel aggrieved, you go to the Court of Appeal, and the two also will be taken together at that level.
At the end of the very illuminating and incisive lecture by Professor Itse Sagay, SAN, members of the audience took active part in the question and answer session, and the guest lecturer took his time to further elucidate on aspects of the lecture that needed to be further clarified. The guest speaker, Professor Itse Sagay, was formally admitted as a bona fide member of the prestigious Island Club and given a special plaque of appreciation for participating in the symposium.
But the members have sat it through. We've enjoyed every minute of your contribution this evening. And I want to say we're indeed grateful. And I think this is the least that you deserve. We've all learned a lot. We've all aired our views. You've given us adequate responses to everything people have raised. You are a reputable legal authority. Your name has been a household word, and you're not new to any of us. I haven't met you myself personally, but I have seen you in newspapers, publications of all kinds. You're very deserving of it, and it's my honor and privilege, as directed by my chairman, to make this presentation to you, sir. And we sincerely hope that we will see you in the Island Club whenever you're around. You're a very busy man, but please take advantage of this membership. We appreciate your contribution today. Thank you, and God bless you.
Special plaques of recognition were also presented to Professor Bolaji Akinyemi and Justice Adeshola Oguntade. The communique of the symposium was read by Ambassador Dr. Gani Adelawal. The event ended with the singing of the Island Club anthem.
Island Club, Nigeria's premier club, is a club for you and me. Island Club, with emblem of the peacock, is for truth and dignity. Island Club is for fellowship, it's interracial, is for